You're listening to the Valley Current.
Welcome into the Valley Current. I thought we should do a little podcast about that article that I saw in the LA Daily Journal.
Yeah, okay, looks
You're
good.
a great writer. You know, you got a lot of information in that article. They should pay you the big bucks for that stuff.
I know. They won't even give me a free prescription. I got a pay for subscription.
What?
Yeah.
That's crazy.
Those guys are cheap.
No, seriously, that's one of the best legal newspapers, and I still get it online, and I think it has great stuff in it.
It does, yeah.
You know what I also get online, you'll get a kick out. I get the New York Law Journal online and in paper form. It only comes like 3 weeks later.
Yeah.
The online version's instant, but the paper form comes like 3 weeks after they ship it out because it comes print,
Yeah.
you know, fourth class mail.
Well, you keep connected to your roots. That's what counts.
I see stuff that I wouldn't see here in California.
Yeah.
I mean, stuff that you don't even know what's going on in New York. There's a lot of stuff going on in New York right now.
Sure.
So tell us what motivated you to do the article, because usually I think of you as more interested in sort of stuff that's not so commercial, but that's pretty commercial, right?
Well, yeah, you know, in my younger days, I did all this pro bono and tenant stuff, but I've gone from pro bono to pro bucco, and, you know, why not?
I have to say, you've made a good transition, because I tell everyone here, I learned how to write a brief from your little booklet that you did about how to write a brief. I think you've since turned it into a book. But it was like a little tiny green booklet back in the day.
Yeah.
You probably still have one around in your office there, right?
I'm somewhere. I'm doing a new one for CEB on appeals. That's.
I mean, a lot of people don't understand that there actually is a method to the madness, and they just think, oh, you open a word processor and away you go. That's not the way you do it.
No, I run into that all the time. I'm helping a guy now down your way write a brief, and he's a good trial lawyer, but he's having trouble.
There are, you know, I'll drop a footnote here and I'll tie this together. I did an interview and a podcast with Rafael Chodos. Rafael Chodos, now Professor Rafael Chodos, I want to say USC or some law school down south. His brother, Hillel Chodos. Hillel was one of the great trial lawyers of the 1970s and 1980s.
I know. I remember his name.
And Hillel he didn't need a note. He could go in front of a jury for 3 weeks, not a single piece of paper. And judges were amazed, like, this guy is unbelievable. But if you asked him to write a brief, he'd be like, I don't do that. Somebody else is going to do that for me.
Right. Yeah.
I mean, it's interesting how, you know, there are very few people as talented as you are that can do the brief writing, the strategizing, and the oral advocacy.
Yeah.
All three. There's very few people that can do that.
I try to keep it very practical.
Yeah, no, and you get a lot done in very little time. You did a great article in that paper about force majeure. So tell us what motivated you to pick up that topic.
Well, I've in my younger days, I did a lot of work in landlord-tenant law, and I never came across this issue at all. But with the coronavirus, you know, I do appeals, and initially my supply of new appeals stopped because there were no judgments coming out of the trial court. Nobody was filing new appeals. So
people don't understand that. People don't understand the full train wreck that's in progress here, right? Yeah. Everyone is stalled. Everything is stalled. It's like
I'm starting to get some more stuff. I'm getting more stuff now, but I had a little downtime, and I thought, what's an interesting topic that's going to come out of this coronavirus? I mean, there's a lot of interesting topics: insurance issues, personal injury claims, employment issues, but this is something I happen to know something about, so I thought I'd look into it. And I kept getting some feedback that this was a live issue out there in the commercial community. And so I put together I write a regular column for the Daily Journal. It comes out twice a month. But this was too long for one column. So they let me have 4 consecutive columns in 4 days so people could see the whole thing, in at least in a week. And that was good. See the basic defenses, see some cases on it, go over the executive orders about closing businesses, and try to tie the whole thing together for them. And so the article ran last week, and the feedback I'm getting is incredible. It's like there's not everybody, but there's a number of lawyers who doing a lot of work in this issue. One guy wrote to me and said, "This is 25% of my practice now."
Right.
The stuff I wrote the article on.
Right.
So
well, there are a lot of real estate lawyers that they don't have the answer. And if you go to a big law firm, they charge like $25,000 for the work that you did in those articles.
I know. I'm doing some work with one of the big law firms I won't mention, who has some huge retail properties that they're dealing with, and they found the piece very useful, and they helped me because they see a lot more leases than I do,
right.
Commercial leases. And the most interesting they told me is they have yet to see a commercial lease that relieves the tenant from paying rent in this situation. And this isn't just their local office in California. Right. This is all over the country. They haven't seen one. And I tend to think there must be some big chain store that rents spaces that has a lot of bargaining power that would put this in, but they haven't seen it. So leases. I thought I'd see a lot of it.
Right. I mean, leases, what are also known in the commercial world as triple net leases, 3 N's, net, meaning the tenant pays everything.
Right.
Typically, those leases are written almost as though the receivable is going to be sold to somebody else in a securitized way, like to some other party that says, hey, that stream of cash flow is worth a lot of money. I'll pay you for it because I like the idea of investing in a stream of payments with essentially a coupon, which is the discount factor, because the stream of payments may add up, right?
Yeah, and the landlord, the owner, I mean, these are huge investments.
Right.
They often want to sell it, especially when the depreciation gets low, and they don't want any risk on their part.
Zero.
I mean, they want it all on the tenant, and then behind them you got the lender who, has a huge stake in this thing. They don't want any risk.
Right.
So they have to approve the lease, of course, and they don't want their borrower to have any risk. So all the way down the line, it doesn't look good for the tenant. And so, and of course, the starting point for the courts is you promise to pay the rent, you bear the risk, you can't pay the rent.
Right.
And you better come up with something damn convincing if you're going to get out of it. So they make it really tough for the tenant to get out of it. And it's possible. And I tried to go through all the possibilities here to at least get a suspension of the duty to pay rent. That's possible, all right? But even after the suspension, you're going to have to pay the back rent.
Right. So you're saying in effect a tenant that comes in on a commercial lease, let's put residential to one side. Commercial leases, a tenant who comes in, the tenant's got to realize if they're going to get any type of negotiated outcome based on the argument that a force majeure or impossibility or impracticability or all these legal doctrines will apply, the landlord could say, look, I'll give you a month or two and we'll tack more money onto the back end. But I just can't let you skate away from this lease like it's an option contract. It's not an option contract.
Yeah.
You've got the space. You got to pay for it, right?
Yeah. Okay. There's two things going on here. I wrote my article about litigation. I mean, what happens if this thing goes to court? and the tenant's got a real uphill battle. Out in the real world right now, the overwhelming majority of these issues are being negotiated pretty much the way you just said. And landlords are kind of in a box. They in some places like LA, they can't even file an eviction action against the smaller tenants. But they know that the tenant's up against it, and they're willing to work something out to either forgive some rent now or at least delay it or something like that. The landlord has his own real problems here because he's got to make his payments to the bank and to the city and the utilities and everything. And does he have a defense against the bank when they come to collect on the mortgage? The same kind of defense as I talk about, impossibility and frustration of purpose are the two main ones. And probably not. I mean, the bank documents, they don't give anything away, right? They don't take any risk. So the landlord, he's got to make his payments. He's got to have an income stream to do it. Maybe the bank will give him a break for more time, but they loan the money. They got the security in the property. They're not going to give up on that. So everybody's kind of in a difficult spot. The landlord also, if there's another possibility here, rescission. End the whole damn thing. You know, 5-year lease, 10-year lease, rescission. The tenant might be able to do it if he's got a good frustration of purpose argument. That won't get him out of the back rent, but at least he can cut off the future. And the landlord might do it if he's not getting the rent for an indefinite period. But that raises some other issues. Does the landlord really want to rescind when he's got nobody else to rent to, right? The businesses are closing, they're going bankrupt, and it's a buyer's market right here. The landlords will give huge discount to get new people in. So if he's got someone already, he might just cross his fingers and hope this thing ends soon, and he keeps the guy. He doesn't want to rescind. The tenant, if he signed a bad lease in the first place, top of the market, and then he's paying too much, he might think, hey, there's a chance to get out of it, right? So he could do that. Or the tenant could think, well, I'm paying, market rent, but right down the street, there's a place that's going at 20, 30% off because the tenant there went broke. So when the tenant asserts frustration of purpose, he might be pulling something, and the landlord might want to be alert to that and use that in court and say, this is nonsense here. That's not really what's going on.
Right, but you said a couple of things that I think are worthy of repeating, which is number one, the courts are not really going to process evictions, so the tenant can probably squat, although there's probably a continuing damage. On the flip side, the landlord's got a slightly different risk, which is the default that occurs in non-payment of rent, which may give rise to a default in the payment to the bank on the mortgage.
Or the city. It could be
the city, or it could be property taxes. But the city typically has to go to court to foreclose. The owner of the debt, or the mortgage company, the bank, let's call it the bank can do what's called a private sale by starting a foreclosure process without an actual legal process. Yeah. Because in California, the trust deed process is a private process that allows a foreclosure to start without a legal filing. A notice filing starts it in the typical trust deed process compared to, say, New York. Going back to New York, New York is very much a mortgage state. You go to court to foreclose on a mortgage. Well, if the courts aren't open, there's no foreclosure. So everyone just sits tight, right? But California is different. And that symmetry, that lack of symmetry is problematic, right?
Yeah. Yeah, these are deeds of trust, and you can foreclose without going to court in California.
Right, so people have to actually worry about this in slightly different ways. And I'm putting your article up just so people can see it, because I do think it's quite a statement. Your article makes quite a statement.
But I'll tell you, the Daily Journal will not allow me to put the piece on my website for a year. But if people are interested and they write to me, I'll send you a copy of the article.
Well, the article, you did send it to me. Is it on the screen now?
Yeah.
Yeah, so to me, it's kind of a good story. When you look at this from the point of view of, say, a tenant, because I've got this case right now and it might be worth focusing on it in the abstract. They're on the 32nd floor of a building in San Francisco. And they said to me, our people don't want to get on an elevator with other people. We've got 100 employees. The elevators are not that fast in the building. There's only 2 sets of elevators. How are we supposed to queue in? We're not going to climb 37, 36 flights of stairs or 32 flights of stairs. What do? We've got a 32nd floor. Do we take the risk that our people just say we're not showing up when the shelter in place rules all change next month or July or whenever it happens here? Do you follow what I'm saying?
That's a tough problem. See, there's 2 possible defenses here. One is called impossibility. And the issue is whether it's impossible for you to perform your duty. Well, the only duty here is to pay rent. Does that make it impossible to pay rent? No, the elevator problem doesn't do it. The other defense, frustration of purpose, is the purpose of the contract being frustrated by this outside force? Well, the purpose of the contract, the lease, is to enable you to use this office space on the 32nd floor. Has the virus prevented you from doing it? It certainly made it tough. I mean, 32 floors, that's a lot of climbing, right, without the elevator. On the other hand, there's the article. On the other hand, the cases on frustration of purpose in California are generally really tough to satisfy. They start with the notion a contract is sacred, you promise to pay the rent, and if you wanted to have the risk of some interference passed on to the landlord, you should have put it in the lease. So there's a couple cases I discuss in my articles. One is really interesting. It was around the time the Second World War started, and this guy leases a space in Beverly Hills to sell new cars, and this is a few months before Pearl Harbor. All right, he signs, I think it was a 5-year lease, and he opens it, starts selling cars. Pearl Harbor hits, and the government says, no more new car sales.
Right.
All the auto plants in Detroit were switched over to making tanks and planes. So
right.
No more new cars. Not totally. They allowed a few to be sold to doctors and some essential people. So he wanted to get out of the whole thing, and they ended up in court. Went to the California Supreme Court, and they wouldn't let him out. 2 reasons. One is, well, it has to be unforeseeable. This wasn't unforeseeable. In 1940, before Pearl Harbor, Congress passed a law allowing the president, Roosevelt, to take over industry to make war goods. He didn't do it because we weren't at war yet, but they passed the law. And we had our army go into Greenland and Iceland defensively. And the court says, because of things like that, which were all in the news, you should have known this could have happened.
Right.
Which I thought was kind of a stretch, but it shows how tough the court's going to be. There was a second reason they gave that's relevant to your question, Jack. They said, well, it didn't ban all new car sales. You could sell to doctors and cops and people that really needed it. And there's a provision in the lease that allowed you to sell gas too. And you can make a few bucks selling gas. So when we talk about frustration of purpose, we mean almost total frustration. So in your case, if there was some way to get some people up to that 32nd floor, they got to wait longer for an elevator just to themselves. Tough luck.
Well, that's like 100. That's like 100 trips up and down, or 50 per elevator. I guess you'd have to queue the people 2, 3, 5 minutes apart, whatever it takes for those elevators. But remember, there are other people getting on 31, getting on 30, getting on 29. I think it's a 50 or 60 floor building, right?
The court in these cases said frustration of purpose means it's destroyed. That's the word they use, destroyed.
Right.
If it's hurt, no, that's not good enough.
So
it's got to be destroyed.
Right. Do you think Civil Code Section 1511 that you quote, Subdivision 2, that talks about irresistible superhuman cause, excuses performance prevented by, quote, an irresistible superhuman cause, and you say in your article the coronavirus would seem to qualify?
Yeah.
Do you think that works, or would you say, no, it only works for a period of time? It doesn't really work forever, right?
That's right. The cases treat these doctrines as equitable doctrines, and everything is relevant. There's no litmus test here. You throw everything into the pot and see what happens. So I think the landlord may have an argument that this thing was foreseeable because there have been articles for the last few years about possible pandemics from climate change, for example. So this isn't totally unforeseeable. I mean, that could happen. Maybe they'd say the tenant, especially, not some little guy, but at least a big company, they should have researchers checking these things out, and they have the bargaining power to make sure this was in the lease if they wanted it. So, and of course, what's different about the coronavirus that wasn't true in these other cases is the landlord has stronger arguments because his back is against the wall. If he doesn't have that revenue stream from rent, he could lose the building to the city or the lender. So it's really tough on him. And I didn't see anything like that in any of the prior cases. He's got a much stronger argument.
So when you look at, say, the 1918, 100 plus years ago, the pandemic that happened then, did people just not litigate? Did they just stay out of the courts? Because we do have a bit of a precedent from the point of view of 1918 was a tough year, right?
I found one case. There was one court of appeal case that came out of that Spanish flu pandemic,
right?
Where a guy making a certain product, it was heating oil or something like that, was delayed by a city order. I think it was in Long Beach. They made him close his plant temporarily.
Right.
And so he completed the order, but he was a few days late.
Right.
And the tenant said, the buyer said, "You're late, I ain't paying for it." And the court went over the facts very carefully and said, "You got to pay for it," that it was close enough. And the evidence was conflicting. And we're going to affirm the trial court that said that the buyer's got to pay. That was the only one I've seen.
So that's an easy case. You would look at that and say that was an easy case. It probably shouldn't have even been litigated.
Well, no, it was kind of a hard case. I mean, it was all done on the facts. I mean, the legal principles were not that complicated, but the court looked very carefully at these dates, what was happening in the factory, and that's true in all of these cases. They really look at it carefully. But I think you're right that there isn't much litigation percentage-wise. I mean, over 90% of these cases, people are sensible and they work something out because, who wants to fight about this when there's a limited amount of money? That's the problem.
Right.
The basic source of the money here from customers paying for stuff ain't happening. So everybody's going to get hurt somehow. But I think it's inevitable that there's going to be lawsuits. I mean, there'll be situations where the stakes are so high that and people aren't going to be able to resolve it, they're going to go to court.
Well, do you think the courts are ill-equipped? Is this a little bit like 9/11, where you have to appoint a master mediator and put somebody in to just act as some sort of super claims adjuster with big government money available in one way or another to decide who gets what?
I don't think so, because there's not one defendant or one group of defendants. It's all, it's just a multitude of landlords and tenants.
Right, but let's pretend. I mean, we get to do this because we're friends and we could do this without sort of saying, "Hey, you're right, I'm wrong." But let's pretend the Chinese government said, "We did screw up, and we're going to give America $10 trillion because we have it all in T-bills. We're going to set up a fund, and you guys figure out how to divide that money." Really interesting idea. We screwed up here. I'm not saying they're going to say that. I'm not saying it's true. I'm pretending that $10 trillion just fell from the sky. And they said, you figure out who gets what because everyone got hurt, but we want to make friends with Americans all over again. We're going to give you 10 or 100 trillion or 1 trillion or whatever the magic number is. Maybe it's a gesture. Maybe it's only 100 billion. But we want to give your economy something because we kind of screwed up here. How would you divide that money? What would you do with it?
I doubt that it would go to commercial landlords or tenants. Any government would have a claim. But see, the other thing here is, the overwhelming majority of these commercial leases have arbitration clauses.
Right.
So it may be that almost all of this stuff, except maybe the little guys, goes to arbitration. And arbitrators are notorious for cutting the baby in half.
Right.
So that it would probably be something very flexible and suitable for the parties. If it goes to court, it tends to be all or nothing with courts.
With your group, you've got a great group of retired judges, and you're the leader of the group on the appellate team, the Moskovitz appellate team. Would your group consider doing mediations or arbitrations? It's not really your primary practice, but would you consider doing that? They
all do it. All those. I'm the only one there without a robe. The guys in the robes are all former appellate justices, and that's what they do. They do arbitration and mediation. ADR and I think they're all with ADR. And sure, just let me know, and I'll line you up with them. They're spread out over the state. The one on the left, Bill Stein, is local here in the Bay Area.
Right.
In the middle, Chris Cottle.
Yes.
Is down your way, Jack.
Yes, I know Chris. I know Bill. I think they're great.
County.
And Jim,
right,
I know Jim.
Ardice,
I think they're great. They're great judges.
Jim Ardice is in Fresno. So, they're all very good at arbitration and mediation, and just use the guy who's closest to you.
Right. I think you've got a great team. I think you've got a great team there. How do people best reach you? They can go to your website, which is Moskovitzappelleteam.com.
It's got our contact information there, and just give me a call or drop me an email, and I'll set you up with that. And,
right, and they can they could reach you through the website, or they could reach you also by phone, right?
Yeah, and we do a lot of consulting. So one thing, we do appeals and writs, but one thing we're doing more and more of is consulting at the trial court level, because when
I've used you guys for that. I think you're very good at that, of seeing the forest for the trees. I've used it for that purpose.
But when we do appeals, we're good, but we're stuck with a record. And if the record isn't good, sometimes there's not much we can do. So if you bring us in early in the trial court level, we can help build a record that'll make it much easier to win the appeal.
Right. So they could reach you directly at 415-570-2122, right?
I think that's it, yeah.
And you also have an interesting email for people that want to send an email. You put win at Moskovitz Appellate Team. So you really want to send the message that I think is very unique. You say, I won't take the case unless I think I can win it, period, full stop,
Well,
right?
that's true. I try not to take losers, and we give people an objective opinion as to whether they should go ahead. And if we don't think it's there, we tell them to save their money.
I tell people all the time that you're the only firm in California that has the equivalent in a small group of north of 300 plus years of experience cumulatively among your people. And you guys don't really do it for the money. I mean, I have to say, I've seen you decline some cases, which I frankly thought you should take, but you're like, look, I don't think we can win this. So send it to Big Law, send it to somebody else.
I'm sure you meant the 300 years as a compliment, Jeff.
Yes, it was. It was a compliment. But there's a lot of wisdom in that group for the number of people you have. It's not like a big law firm where, you know, there's a lot of people, but they don't really have a lot of experience. You got big density of experience there.
I'll tell you the interesting part of that. I and some of my judges too, and, you know, they're generalists. They're older guys. They're on the Court of Appeal, and they're not specialists in any way. And we've consulted and done moot courts on very technical stuff, computer stuff, patent,
right.
trademark stuff.
Right.
And one would think, you know, we're out of our depth, but we've been very, very helpful in bringing the human side of it in, because, you know, these lawyers, they're talking about gigabytes and all this very technical stuff. And, you know, I'll come in and say, I had one case with a big firm. I won't say who they are, but this lawyer was arguing it, and he was good. He really knew his stuff. But at the end, I said, I've read your brief, and I read the other side's brief. The other side was written by a former Solicitor General of the United States, really good. And he basically called your client a liar and a thief. And I read your reply brief, and you didn't respond to that.
Ouch.
He said, well, I didn't need to. We're right on the law. I said, wait a minute. That's not the way it works in the real world, right? You have to respond to that. You made a good argument, but this other guy made a good argument on the law too. The court has a choice. Now, when they have a choice, who are they going to rule for?
And that's
the guy or the thief.
Right. That's a lawyer that's probably billing $1,500 an hour, and he has forest for trees, right? And
he grumbled. He said, "I don't want to do it." And then the client was in the back room, and he basically said, "You fucking do it." And he said, "All right, I'll do it." And I said, "You really ought to put this on your first page of your brief." He said, "What?" I said, "Yeah, first page."
Sometimes you just can't take the horse to the water. You got to push them and pull them and drag them, and they'll finally drink the water that they need to drink, right?
Yeah. And, who am I? I'm not some copyright specialist, but I've been there. I mean, especially if you're arguing, there's one thing if you're arguing to the Federal Circuit, but even those guys put their pants on one leg at a time, and it matters to them. But especially if you're arguing to the Ninth Circuit, where they're not specialists.
So let me end with this remark. Judge Michelle was on a podcast for CLE earlier this week, or maybe last week. The weeks are becoming blurred to me as a result of working out of your home. But he said, I would rather have the great advocate in a patent appeal or even a patent trial than someone who's really technical but can't communicate. You guys know how to communicate. We like to say we prefer lawyers in our firm that communicate well, both verbally and in writing. And the technical side they'll pick up, or we'll use expert witnesses for, or we'll use consulting experts. We're not going to lose the zealous advocacy in the process. That's what's.
I use you. You know this stuff really well.
Right.
So, but I think we can be very helpful no matter what the issue is, because, we're advocates, we're human, and you got to get out of that technical box.
Right. Hey, thanks, Myron, for spending part of your afternoon. I will look for the rest of the installments, and we'll do another one as we start seeing the cases come in, because we're going to see them in many, many different contexts.
Good.
Okay.
Thanks, Jack.
Have a good afternoon.
You too.
My regards to your lovely wife.
I will.
Sure. Bye-bye.
Tune in next time on the Valley Current.